following program on KROC is sponsored and paid for by Meshbesher Spence.
And look who's here, Zach Bauer from Meshbesher Spence.
Been a long time.
It
Long time
certainly
no
is.
see.
We thought maybe you've had a new contract or something that says, please, no more radio with those two.
No, I love you guys. I love you guys.
Oh, you had that qualifier at the end.
If they gave me a contract that said I didn't have to hang out with Andrew, then that wouldn't be something I'd take up on.
You guys are messing us up, though. He came in last week all dressed up, tie and the whole 9 yards, and you come in with a sweater. What's up?
It's
like
winter.
Once every year we change roles, so this is the day.
I like it.
All right. Well, we're going to talk about some of the recent cases involving DUI tests of blood and urine. The state Supreme Court made a ruling.
Getting on board with the rest of the country, so that's good. Last thing I think we talked about maybe in the middle of summer last year was that the Minnesota Supreme Court had ruled that warrantless breath tests, I mean, the situation where a person's picked up and an officer says, hey, you need to consent to a breath test, and the person refuses. Mm-hmm. The challenge was whether or not that was an unreasonable search and seizure because the fact there wasn't a warrant, and secondly, because you were going inside the person's body to be able to take a breath sample. And the Supreme Court said, no, law enforcement can do that. It's a search incident to arrest, which is one of the exceptions we have to a warrantless search. And they basically kind of play that off as, well, breath is not maybe as invasive as, for instance, blood, where the United States Supreme Court had said very clearly that's not something you can do in a case out of Missouri. Well, there have been some changes. Times are changing. So urine and blood, both cases from August of this year and December of this year, have said that if a law enforcement officer asks you for a urine or blood sample and does not have a warrant, you have a right to refuse that. Now, that's important from the standpoint of now law enforcement is going to have to go out and get warrants in those situations in order to effectively kind of do their job. It's going to be a huge shift.
So how long does that take to get a warrant?
Well, that's going to be another kind of interesting question, is that law enforcement typically has, although there's a little bit of timing there as well, but typically 2 hours within the time that they come into contact with the driver is when they need to try to get a sample. They need to be able to show, as part of our statute, that the person is under the influence over 0.08 within 2 hours of their driving conduct. Now, they can show that in different ways. For instance, they could take a sample 2.5 hours after the driving conduct and then have somebody from the Bureau of Criminal Apprehension lab say, okay, this is where they were at 2.5 hours, this is where they would have been within the 2 hours, but that costs more money, takes more time, puts more stress kind of on the justice system. So 2 hours is kind of that time frame. There's telephonic warrants now, and I think that eventually this whole process is going to be difficult to get up off the ground for law enforcement. A lot of money it's going to be spent doing it. But once it's set up, I think it will run fairly seamlessly. There'll be a judge, I'm assuming, that will be on call to some degree. And
I would think you could do it online anymore.
Yeah,
just say, click here for a warrant.
Yep, can simply sign away on an online system and be able to provide that warrant that's necessary. But the time being right now, where we sit now from basically August to current status of things, is that the person has the right to refuse. Now, one of the things that people need to understand, this applies only right now to blood and urine.
So breathalyzer.
If they ask you to take the breath test, you have to take it. That's the way the law currently stands. Now, that may also change because the ruling that the Minnesota Supreme Court made back in February of 2015 has now been taken up by the United States Supreme Court to see whether that was proper. So that may change as well. The whole implied consent statute may be changing. But if law enforcement gets a warrant, you have to consent. If it's a breath test, you have to consent. If it's a blood and urine test, you don't have to consent. You can refuse. The one thing you need to understand, though, is that if you do refuse, your license is going to be revoked for a year.
Just because you refused?
Just because you refused. So your license is going to be revoked for a year if you, and that's very important for those people that may just be barely over the 0.08 legal limit at the time of that test, because if they have provided a test, either blood or urine, and they're at 0.08 or 0.09 or all the way up to 0.15, their license will only be revoked for 90 days. So there's some types of kind of gamemanship of you may lose your license a little bit longer, but for right now, blood and urine, unless you have a warrant, you have the right to be able to refuse that right now.
I have a better solution for all
Don't
of
drink
this.
and drive, right?
Hey,
there we go.
Stop reading my mind.
If it were that simple.
If it were that simple.
Yeah.
Right? Yeah.
But, you know, I just get a kick out of that ruling, though. I mean, yeah, you can. We're going to make it so you can refuse to have your body invaded without a warrant. However, if you do, you're going to, you know, your punishment is a lot worse. I mean, it's just that doesn't sound right for some reason.
There's been a lot of back and forth when it comes to criminal penalties, the civil penalties. What I assume is going to happen, if I had to kind of a crystal ball where we are a year from now, what will happen is that refusal will not be considered a crime. That will not be something that will be read to you, that you'll have the ability to basically refuse that test. But that there will also be the ability of the state, the Department of Public Safety, since driving is a privilege, not a right, to be able to say, if you want to take the test, we'll revoke your license for 90 days. If you don't want to take the test, we'll revoke your license for 2 years. And that's your difficult decision you need to make. And the United States Supreme Court has upheld time and time again that those type of decisions, when it's not a crime, but you have to make a decision between giving evidence against yourself or losing a privilege when it comes to your license, that's okay.
So what advantage would it be then to refuse the test?
Well, one of the reasons why you could potentially refuse the test would be that if, for instance, you had not done field sobriety tests, or you thought okay on field sobriety tests, if there is no actual blood concentration for the state to rely on at the time of trial, then they have to prove that you're under the influence based upon your driving conduct and how you did in the field sobriety test. And that's a difficult chore for a prosecutor to be able to prove. Not impossible under some circumstances, but difficult for them to be able to convince a jury beyond a reasonable doubt. It's much easier just to say, listen, they're .10. They're over the .08 legal limit. You know, it's a done deal, so to speak.
Well, how accurate are the breathalyzers?
I think they're accurate at this point enough to be able to kind of pass judicial scrutiny.
So, I mean, there's really no need for the blood and urine unless under certain circumstances.
There is no real need for the blood and urine unless there are special circumstances. Now, there are situations sometimes when the data master is not working. I had a recent case down in Fillmore County where that was exactly what happened. They asked him to give a breath test. He said he would give a breath test. The breath test didn't work properly, so they asked him for blood and urine, and he kind of felt like he was being jerked around at that point. So there's all kinds of different, I guess, anecdotal cases to talk about, but quite frankly, that's where we are right now.
Well, yeah, it does kind of go back. The bottom line is get another person to drive you who hasn't been drinking, or just stay home.
Don't drink and drive, and like I said, make accommodations so if you are out and having a good time that you find a safe way home.
Somebody needs an attorney at Meshbesher Spence. How do they get a hold of you?
They can call us at 507-280-8090 or visit us online at www.meshbesher.com.
Zach Bauer, enjoy the weekend.
Great to see you guys.